Ready, start. This rule is said to be founded on the tenderness of the law for the rights of individuals and on the plain principle that the power of punishment is vested in the legislature and not in the judicial department, for it is the legislature, not the court, which is to define a crime and ordain its punishment. When the proviso within bracket B to section 138 stipulates the service of notice as one of the conditions for constituting the offense, and when the words single inverted comma said amount single inverted comma clause is incorporated in the language of the provision, it is the amount which is specifically referable to the amount recoverable under the check in question. Reading section 138 of the Act in a composite manner, the word single inverted comma said amount single inverted comma clause occurring in the proviso within bracket B is connectable with and operates in conjunction with language in the parent part of the section single inverted comma where any check drawn by a person of any amount of money single inverted comma clause. The words single inverted comma said amount single inverted comma clause and the phrase single inverted comma any amount of money single inverted comma clause have the same purport, signifying the check amount. The nexus or linkage between the two is enacted by the legislature with a purpose of making the two to be the same and inseparable components, the former describing the offense and the latter denoting the condition to be fulfilled for constituting the offense. From the aforestated reiterative pronouncements and the principles propounded by the courts, the position of law that emerges is that the notice demanding the payment of the amount covered by the dishonored check is one of the main ingredients of the offense under section 138 of the NI Act. In the event of the main ingredient not being satisfied on account of discrepancy in the amount of check and one mentioned in the notice, all proceedings under section 138 of the NI Act would fall flat as bad in law. The notice to be issued under proviso within bracket B to section 138 of the Act must mention the same amount for which the check was issued. It is mandatory that the demand in the statutory notice has to be the very amount of the check. After mentioning the exact check amount, the sender of the service may claim in the notice amounts such as legal charges, notice charges, interest, and such other additional amounts, provided the check amount is specified to be demanded for payment. A failure in the above regard, namely when the check amount is not mentioned in the proviso within bracket B notice or the amount different than the actual check amount is mentioned in the notice, such notice would stand invalid in eye of law. The notice in terms of proviso within bracket B being a provision in penal statute and a condition for the offense, it has to be precise while mentioning of the amount of the check which is dishonored. Even if the check details are mentioned in the notice but corresponding amount of check is not correctly mentioned, it would not bring in law the validity for such notice.